This video is the 10th in a series of 17 videos on the subject of appointing custody evaluators and the appointment of guardians ad litem, or GALs for short, in Utah child custody cases. You do not have to view all 17 videos to benefit from this series. Watch as many or as few as you wish. The purpose of this series is to make the case for the proposition that an interview by the judge is a faster, more accurate, more particular, more reliable, and less expensive form of evidence than what a GAL and/or custody evaluator provides. When the judge's interviewing children harms children argument is finally abandoned by those who acknowledge it's a silly and patently invalid argument, the next argument to which some cling in their efforts to prevent judges from talking to children directly is this one. GALs and/or custody evaluators develop a much deeper understanding of the child's circumstances, needs, and desires than would a judge interviewing a child. But a guardian ad litem does not spend that much time learning about a child, his parents, or his environment, and does not establish an especially trusting or otherwise meaningful relationship with the child either. I've talked with GALs and custody evaluators and with people who had them appointed to speak to them when they were children. The guardian ad litem and/or custody evaluator may have spoken to them for an hour or so. No more than the amount of time a judge could and should spend speaking to a child as well. To assert that guardians ad litem and/or custody evaluators do a far better job of interviewing children than a judge can, because GALs inherently care more or put more effort or time into it, is demonstrably false. First, if there are any private guardians ad litem out there who spend more than an hour or so talking to the client before going before the court and making recommendations based upon the interviews with the child, I don't know who they are. I have never had a guardian ad litem do that in the cases I've handled. And if any of you claim that you generally spend or need to spend more than an hour or so interviewing the child, please provide some independently verifiable proof. I have never witnessed a private guardian ad litem meet or speak with the children multiple times for multiple hours. Even if they did, how would we ever know? None of their conversations is or are made part of the court's record. How could a guardian ad litem speaking with the parents or speak with the parents, I should say rather, unless the parents are proceeding pro se, without violating the rule against communicating with a represented party? On the extraordinarily rare occasion that the guardian ad litem has sought permission to speak with my client, the conversation has been brief and not in depth, and in a way that doesn't come as a surprise. The guardian ad litem doesn't speak for the parents, after all. The parents can do that for themselves. Come to think of it, except where a child is too young to communicate effectively, children don't need a guardian ad litem or a custody evaluator to speak for them either. They have their own voice, and they should be permitted to voice their experiences, observations, feelings, concerns, opinions, needs, and desires by themselves, in their own words, unfiltered and unadulterated. But what do I know?